I'm looking at an order you issued as a magistrate judge here, requiring the use of pronouns in your court. Do you require the use of pronouns, the declaration of one's pronouns in your court?
Senator, that may be referring to perhaps a trial management order or a scheduling order of some kind?
Yeah. No, it's a statement. You issued it. Here it is.
It's an invitation for people to identify their pronouns and or their honorifics.
Well, I'm looking at your requirement that you issued to all people in your court. You say, quote, when you introduce yourself in a meeting, you should say, my name is Judge Blank and my pronouns are blank. Is that right?
Senator, those were not requirements or rules. Those were suggestions and
they were suggestions.
Those were suggestions and invitations for people to use.
And you also, in your directive, you say, quote, I'd like counsel to introduce themselves giving your full name and your honorific, such as Ms., MS period, Mix, or Mr., not Mrs. And if your client will be making an appearance, I ask you to please introduce them to the court by giving me their full name and their honorific, such as Ms., MS period, Mix, or Mr. End quote. Is that right?
Senator, it's not a directive. Again, it's an invitation for people to introduce themselves.
Invitation. Yeah. Okay. All right. I'm looking at an article from the Oregon State Bar Bulletin from May of 2021. And I want to read one of your quotes. Quote, we have to set aside conventional ideas of proof. Let me say that again. We have to set aside conventional ideas of proof, you said, when we are dealing with the personal and interpersonal work of equity, division, and inclusion. As a judge, I can appreciate the challenge of employing a different mode for understanding truth than that which most lawyers are accustomed to in our work, end quote. Did you write that?
That is a quote from that article.
So when we're dealing with equity, diversity, and inclusion, we should set aside conventional ideas of proof. Is that right?
In the larger context of interpersonal and personal relationships, the idea of being able to have a conversation with somebody.
Yeah, but you didn't talk about a conversation. You said proof.
It's in the context of having a conversation with somebody about the issue of their background and their experience.
So when the issue is equity, diversity, or inclusion, we should have a different set of proof. Is that right?
When it comes to the space in which people have interpersonal relationships with one another, the idea of respecting and dignifying each other with their experiences is an important part of...
So all issues have one set of proof, which has been handed down by our state Supreme Courts, our U.S. Supreme Court, except you think we ought to have a different set of proof when equity, diversity, and inclusion are at issue. Is that right?
In all of my years on the bench, Senator, I have applied the law, the rules of evidence, the case precedent.
Let me move on. I'm looking at the notes you gave us from a speech you made in February 7, 2020. It's entitled Speech Reflections on Equity and Privilege to the Oregon Blacks in Government. You wrote, quote, white, male, straight people allow privilege to remain in place, close quote. Did you say that? Did you write that?
Without looking at the specific speech here.
You turned it in.
Well, if that's on the piece of paper, Senator, then I have no reason to disagree.
You also wrote, quote, privilege is incredibly similar to narcissistic personality disorder, close quote. Did you write that?
Without looking at everything in the context of that statement, it appears correct.
Okay. You wrote, quote, the identity of Muslims also need to be normalized in a country that is so deeply Islamophobic. Did you write that?
Senator, I did. And what I'd also like to clarify is that in the context of my work on the bench, I have treated everybody equally without regard to their
I'm
background.
sorry, I just want to get through this. I'm going to run out of time. You also wrote, quote, I am disappointed about the way in which the founding fathers of this country perpetuated inequity, close quote. Did you write that?
In the context of the issue of slavery, that was something that I had been considering.
In your notes you gave us from a speech on May 17, 2023, does race matter? You said, quote, does race matter? Hell yes, close quote. You know that T-shirt at the Saturday markets, the one that says something like love, see no color, and it has all the colors of the rainbow all over it, and it's like a tie-dye shirt. Well, the first time I saw it, I said, how sweet. Then I got angry. If love doesn't see color, then I don't have allies, close quote. Did you say that?
Yes, and that was to explain that the work of equity is to help understand where people are coming from, not to ignore who they are.
And you also, yeah, no, I'm sorry. Can I have 30 more seconds? Judge, you seem to be obsessed with race and sexuality. I mean, you even go so far as to say that when race and sexuality and diversity and inclusion are at issue, we need a separate standard of proof in the United States federal judiciary. How are litigants going to be able to trust you?
Senator, that's not what I've said. There is no different standard.
It is bigger than Dallas. I read it to you.
When you look
turned in these documents. I didn't go looking for them.
When you
seem
look
proud of it.
As anyone who reviews my record on the bench,
I have
thousands of cases.
I'm going to let you finish responding, and your time has expired, but go ahead.
The rule of law is an absolute for me. The work that I have done on the bench over the last 16 years.
That's not what you say.
The work that I've done on the bench.
But that's not what you say.
Judge, finish your sentence.
The work that I've done on the bench in ruling over all the people's cases that have appeared in front of me from all backgrounds, of all faiths, you'll find that I have upheld the rule of law and upheld the precedent of our Constitution and our Supreme Court and the Ninth Circuit.
Well, if this chairman would give me time, I could go through the cases and prove that that's not the case.
Senator,
I just don't see how you can be a fair-minded judge.
Senator Cruz.
Thank you, Mr. Chairman. Judge Katsubai, I think your fellow nominees owe you a debt of gratitude because many Biden nominees have been extreme, but your record is so far out of the mainstream that you have attracted virtually all of the questions. I was particularly intrigued by your statement to Senator Blackburn that you said you are not, in fact, a Marxist. And then you said, and I wrote it down, I have not praised Marxist ideas. Now, as you know, in law, there is the fact of evidence. And so let's go to something you wrote, an article that is entitled Centralized Property Theory, in which you wrote, it begins, it's on the front page of your law school newspaper. You write, quote, intimate knowing, the lovers kissed, familiar and ever exciting, passionate transcendence. Beyond the physical exhilaration lies a burning light in our limbs, our hearts. Floating, flying, falling in every direction, amorphous and wonderful, time-stretching, space-curving, exquisitely explosive eros. And yet I timidly tremble every time. Now, somehow this is about property, which is not immediately evident as to why, but later in the article you write, you say, property is not simply a relationship between an owner and an object of ownership. Property is primarily a complex relationship between people and secondarily regards the objects people exploit. Historically, three paradigms have dominated European notions of property. Locke appealed to the notion that labor points to who has the right to exploit property. Bentham relied on utility to dictate who has rights based on how the property is exploited. And Marx was plainly disgusted with the alienation that property imposed and its establishment of an us and them and haves and have-nots. Each theory alone denies important components of human experience. Among them are the ability to work, the need for personal privacy and boundaries, and uniquely diverse desires which spin us all in differing life directions. However, the process towards integrating all three may provide a framework for relationships that enhances each unique self. The aspiration towards intimate knowing, the intimate knowing of oneself and others, is a creative struggle towards redefining property. What the hell does that mean?
Senator, when I was preparing and reviewing my materials for this hearing and for the process, I also have to admit that that writing was far from clear or articulate, and the poetry was definitely not good. Now, Senator, I don't make...
Do you believe we need to have a creative struggle towards redefining property, which is what you were advocating for?
That was something that I wrote 30 years ago, Senator, and in the course of just exploring law school and the ideas that came with...
Okay, so your flirtations with Marxism were 30 years ago, so let's go more recent. In 2020, you gave a speech entitled Reflections on Equity and Privilege, and you said, quote, "First, the world is wide enough for all of us. Privilege derives its power from the belief in scarcity, scarcity of money, natural resources, food, and power itself. The desire to control it all drives privilege. I want to suggest to you that equity, the idea of equity, rejects this model of scarcity." Now, that's Marxism in 2020. What did that mean?
I've never considered that to be Marxist, Senator. It's the idea that equal access, and in the context of the work that I do here...
So there is no scarcity, there are no property rights. Equity gives everyone an entitlement to each other's property. Is that right?
Not at all. And in the context of the work that I do on the bench, Senator, when you look at my record for all of these 16 years, you will find that I have upheld the Constitution and our case precedent.
Okay, well, let's turn to something else you wrote in the Wisconsin Women Law Journal. Again, this is your writing. The name of the article is Destabilizing Power and Rape, Why Consent Theory and Rape Law Has Turned on Its Head. You cited Professor Catherine McKinnon, who argued, quote, "Sexuality itself is a power web in which heterosexual relations per se are infused with violence and control, and, quote, most intercourse is rape." Now, her views are extreme, and yet, and when Senator Blackburn asked you about them, here at the hearing, when you want to be confirmed, you try to distance yourself from them. But here's what you wrote in the article. You embrace those views. You wrote, quote, "I employ the view that rape is sex in order to focus on the significance of consent in rape law. The Sex Act is a violation per se without consent. In order to properly align the consent doctrine in rape law with consent in other areas of law, non-consent must be presumed." Do you believe that is a mainstream view, that heterosexual sex is rape?
Senator, in that article, I was exploring different ideas and theories, and I was employing the hypothetical that you've just described to try to tease out a particular issue with respect to consent. With respect to your last question...
So you also quoted Professor McKinnon, who wrote, quote, "Sexuality is to feminism what work is to Marxism." Let me ask you again, what does that mean?
Senator, I was summarizing different theories that people were presenting, so that way I could explain them and then employ an analysis with respect to the issue of what consent was in the context of sexual assault back in 30 years ago.
I think your views are far, far out of the mainstream.